Welcome to Delfino Business Brief, and we are going to have today Francisco Mundaca from the Mundaca Law Firm. He's the managing partner or a founding partner of the Mundaca Law Firm. We're going to discuss about the new ruling from the Supreme Court in Virginia, which has declared that the commissions are not considered wages, and we're going to discuss with him what this means for business owners and employees who earn based on commissions. And we have Francisco Mundaca here with us. Francisco, welcome.
Thank you, Giovanni, and thank you for having me.
Thank you. Please tell us, what does it mean to employees and employers who rely on these kind of contracts?
Absolutely. The Virginia State Supreme Court declined to automatically classify commissions as wages under the Virginia Wage Payment Act because the statute ties to earned, calculable, and non-contingent compensation. So essentially, it is removing these types of, if it is not stated in the letter of the agreement or how commissions are earned, then it will no longer attach to the state, which is significant because then contract law will apply.
Now, what practical impact this will have on commission-based workers' ability to recover and pay compensation, for instance?
So what this is going to do is increase the burden on commission-based employees. So it heightens the importance of how commission plans are drafted and administered. So one of the things that we're going to have to do moving forward for all parties essentially is to make sure that contracts are not ambiguous and that they're clearly stated and precise to show when commissions in fact will be earned and vested. Now, the biggest impact, in my opinion, would be that Virginia State will no longer apply this law that permits for the recovery of attorney's fees and other statutory remedies. That is significant because contract law, while it is clear, it has essentially been around for hundreds of years in our country. It has not allowed for the recovery of attorney's fees and other types of damages unless it is stated in the agreement. And so, one of the things that we'll have to remember is that while the Virginia State Supreme Court has ruled in this manner, it does not eliminate the FLSA, which is the Fair Labor Standard Act, and that has its own protections and own ability to recover damages. And so frequently attorneys will argue that both laws apply in order to maximize damages and protect the individuals. But it is something to keep an eye on if we see these types of trends occurring across the country.
Okay. So what should employers do now, or even employees, for instance, who rely on these kind of contracts? Should they renegotiate, or should they be in a process of developing new contracts? What should we do? What should be done?
That's a great question. I think there has to be two sides. So essentially, the employer has to ensure that their contracts are drafted correctly, that there is an ambiguity, that it is clear and concise, and it specifically states when commissions are earned. From the employee side, it's always important to review these contracts with an attorney so that they can explain to you when these commissions are earned, so that there is a clear understanding and the expectation isn't there, and that they realize the type of agreement that they're entering into.
Great. And what would be any broader trends in wage theft and wage payment litigation post amendments of these Virginia wage laws?
Well, that's also a great question. I think the idea here is that it's curious to me that now we're defining it based on the actual letter within the contract. So attorneys like to say within the four corners of the agreement. That is what the court did here. If it's not explicitly stated, they are not going to go outside into speculate as to what the intention of the contract is. So we're starting to see a slight shift there. Now, again, while the federal laws have not changed, it is something to watch to see how the state courts move and whether this is the first of many changes across our country.
Great. Any additional comments you would like to add before we close this conversation?
Invest in your contracts. The contracts, they prevent litigation. They keep things clear. It's transparency at its finest. Because if it's very easy to submit a contract, and one of the things we see in our practice is AI drafting contracts. There are a lot of holes and gaps in those agreements, and the litigation costs that will precede that is going to far outweigh the investment at the outset to draft an appropriate contract.
Great, that's a great, especially nowadays, as you know, people are using AI for a lot of things, especially even for drafting contracts. That's a great point, and this will be really important to make sure that these contracts are well stipulated. Thank you, Francisco, for this few minutes to discuss with you, and happy to have you soon again with more information.
Thank you, Giovanni. Thank you for having me.
Thank you. He was Francisco Mundaca from the Mundaca Law Firm to discuss about this new development, the Virginia Supreme Court ruling on commissions and now not considered wages. We'll come back with more information soon through the Delfino